I mean, there are a lot of pitfalls that happen in the process of buying and selling a business. One pitfall is that the buyer and seller know and trust each other, and therefore, and then assume that their relationship and the trust excuses them from getting their hands dirty in terms of investigating the business and going through the formalities. If you have a friendship with the person you're doing business with, that's an argument to do your due diligence so that you can preserve the friendship. Because I guarantee you, there will be surprises later and it's going to affect the friendship. So just don't skip over your research and due diligence just because of a prior relationship with the buyer or the seller. That's number one. Number two, a real common pitfall is a situation where both the buyer and the seller are represented by the same broker. I see problems that come from that because in that situation, neither party is really getting its needs addressed. Because the broker in that situation is incentivized to push through a middle of the road agreement. And I guarantee you those middle of the road agreements are ambiguous. They're a little bit wishy-washy. They have language that goes both ways, and nobody ends up knowing where they stand. And unfortunately, I see a lot of those agreements 6 months after the purchase, and it's a lot more expensive to deal with it than it would have been had both the buyer and seller gotten their own attorney to identify their own interests and advocate for those.